Right, let's make a start. We've got lots to be looking at this morning. So, yes, an immigration update for the next 45 minutes. No better way to start Tuesday morning. So, really good to have you with us. Just a bit of housekeeping to start with. There will be a recording of the session afterwards that hopefully we'll put on our website and also make available in other ways. And if you want to ask a question, during the session, do pop a question in the Q&A box and we'll try and pick out some themes or topical questions towards the end of the 45-minute session. We've got lots of people with us today, so it's inevitable we just won't be able to cover all of the questions. Hopefully forgive us, but we'll try and pick out some common themes that are coming through. Great. So what are we going to do for the next 45 minutes? We're going to have a little bit of a recap and a look at right to work check issues. So some new employer guidance was issued on the 23rd of September. So we're going to look at some of those changes, particularly around who you should be doing checks on and some changes in that area. Mark's going to give a bit of a topical question for us to think about. Something that we often get asked lots about at Christmas time. So an exciting thing to anticipate that question. We'll have a bit of a skilled worker update. So look at some key changes over the past few months since our last update back at around the time of the changes on the 4th of April. Patricia's going to do a bit of a roundup of other developments, a few things going on in terms of a phase out of biometric residence permits, the electronic travel authorization scheme, eVisas, some of those things she's going to cover off. And we'll finish with a little bit of horizon gazing, whatever you want to call it, about the new Labour government. So what is the government going to be doing, likely to be doing? Are we going to be seeing any significant changes in terms of immigration policy? So lots to get through, 45 minutes. We do need to finish bang on 11:15. So, right to work checks. Let's get stuck into that, shall we? There has always been a bit of a debate over the years. Well, who should you be conducting right to work checks on? And we all know, I'm sure, that there are three categories of staff, if you like. You've got employees, workers, and self-employed. So employees, a full spectrum of rights. Workers, a few less rights than employees, but look a bit like employees in lots of ways. And the self-employed people who are self-employed contractors. And this often presents difficulties in particular sectors like higher education, research sectors where you've got lots of mobile staff coming in and out, visiting, collaborations, those sorts of arrangements. How does it work? What should you be doing to ensure you have a robust system to prevent illegal working, complying with the sponsor duties, complying with the employer right to work check guidance? And the new employer guidance that came out from the Home Office on the 23rd of September, I think, does underline and amplify the breadth of the obligations that apply to employers. And that's what I'm going to look at this morning, and what I know is an area that lots of you grapple with. And it also highlights some of the ambiguities in this area, which are not perhaps very satisfactory. Starting with the basic stuff at first, the obligation to conduct a check applies on a person who's employed under a contract of service or apprenticeship, whether express or implied, whether written or oral. That is the classic statutory definition of employees contained across most employment legislation. So in order to get a statutory defence to a civil penalty for employing an illegal worker negligently, you have to do the check set out by the Home Office, which varies, of course, depending on the person's circumstances. Now, the Home Office is unlikely to distinguish between employees and workers. In practice, they often look quite similar. You don't really want that debate on an audit. A worker may in reality turn out to be an employee just by virtue of the arrangements on the ground, and you've got broader responsibilities around illegal working. So the position really has always been essentially anybody who's an employee or worker, basically as a rule of thumb, anybody you put through PAYE, you should be doing full right to work checks on, consistent with the guidance. Now, one of the trickier areas has always been, well, to what extent is there a broader obligation than that, extending to self-employed individuals or indeed other categories of staff that you might have. And the guidance issued on the 23rd of September contains this wording, and look at the first paragraph in particular. So where the worker's not your direct employee, for example, they're self-employed, you're not required to establish a statutory excuse. Okay, fine, we know that. But you must, I've highlighted that red, still carry out these checks and retain evidence you've done so to comply with your sponsor duties. Interesting. And then the paragraph below essentially is encouraging employers to carry out checks or ensure that checks are carried out for people who are supplying staff to you. So on the face of it, a much broader obligation. Yes, you conduct it for all employees and workers, but the self-employed, interesting. This is quite a broadening on the face of it of the obligation, albeit with some ambiguity around exactly what that looks like. So kind of where does that leave you in terms of formulating your approach to right to work issues? I think it's important to note that if you're a sponsor, you've got broader obligations than simply establishing a statutory excuse to civil penalty. You can't just say, that's my obligation under the guidance, that's all I'm doing, end of story. You've got an obligation to prevent illegal working as a general sponsor duty, and there are compelling reasons that the Home Office gives for conducting checks for broader categories of staff around things like health and safety, safeguarding, insurance, those sorts of things. Having said that, for lots of us, that is quite a complicated state of affairs to get into. It's not necessarily possible or practicable to be doing checks for all people who are self-employed contractors, notwithstanding that wording in the Home Office guidance that you must do so as a sponsor, and by implication, it's sensible to do so even if you're not a sponsor. I think where you end up is you do have to adopt a bit of a risk-based approach where you balance legal and practical considerations. What are the higher risk features here around people who are self-employed or other categories of individual that you might be hosting? I think where you've got somebody who's doing work for your benefit under your direction, it is going to be sensible to be doing right to work checks. So somebody that you're engaging with directly who is a contractor to do a project for you for a time limited period or a specific project, it is clearly sensible, particularly if you're a sponsor, to do checks on that person. If there's some sort of direct contractual nexus or arrangement that ends up with the person being provided to you, I think that's also a sensible step to be taking. So, for example, you might have a secondment arrangement where somebody is seconded to you for several months. They're working with you, delivering value for you as the organisation. It seems sensible to be doing a check on that person, or at the very least checking that they do have the right to work, even if it's not a full-blown compliant Home Office check. Where does that leave us? I think in summary, what are the practical tips here? You've got to do full right to work checks on all employees and workers. Tick. We know that. That's obvious. The risk-averse approach, given the clarity of the wording in the Home Office guidance, is also to conduct checks on all self-employed contractors, particularly if you are a sponsor. It may be regarded as, well, probably will be regarded as not being consistent with your sponsor duties if you don't do that. If you can't do full right to work checks on all people who are self-employed and engaged by you, then you need to adopt a risk-based approach and think of some mitigations to deal with that. So, for example, if you can't do original checks, can you at least get copies of documents from somewhere that show the person has the right to work in the UK? Is it possible that you should draw lines in the sand so that if you have somebody who is contracted for at least a month or more, you will do right to work checks, but people that are just with you for a day or two, you might take a bit of a commercial view on it and accept some risk. For honorary arrangements, they may not be doing much work for you. It may be a titular title, but you may get asked about it. Sensible to be doing checks on those people. So you have to sort of look at your structure of your workforce, assess in reality how you manage these issues, and adopt that risk-based approach, accepting that you can't necessarily do everything that would be ideal, but identifying the high-risk areas to deal with. Agencies that are providing staff to you, I think it's sensible to ask them to provide copies of the right to work checks that they've done on the staff that they are providing to you, or at the very least, ensure that there is a process in place whereby it's clear that they are undertaking checks on those staff. And even more broadly, I think if you're entering into agreements with third-party service providers to provide staff to you, again, you want to be able to show, I think, that this is on your radar and that there is an obligation on these providers to do right to work checks. I don't think it's necessary for you to be doing them as the end user, as it were, but that organisation, for example, in a service agreement with that organisation, should be under an obligation to be conducting right to work checks and ensuring staff provided and supplied are having those checks done and have the right to work in the UK. So some food for thought there. I think it probably is the case that for some employers, there are things to think about around how you do right to work checks across the full breadth of your workforce, particularly if you're a sponsor, where those risks, not just around the civil penalties, but also around the danger to your sponsor license, need to be at the forefront of your mind. Mark.
Yes, thank you, Alex, and good morning, everyone. So, gonna touch on a bit of a topical point here. So we have put a question on the slide for you. What should you advise an employee who wishes to travel outside of the UK with a pending visa application? So what we're talking about here is an individual who is in the UK, has a visa, and is applying for a new visa before their previous visa expires. And they come to you and they say, well, okay, I want to be leaving the UK. Now, obviously, this question is relevant at all times, but it is particularly prevalent as we are in the run up to the Christmas period. We field a lot of these questions, in November and through into December, because migrant workers are planning on taking some time off, potentially planning on going and visiting their family in their home country, and obviously some of those migrant workers may be in the process of renewing their visa. So, a very topical point right now. Really, there are three elements that I want to touch on this morning. So the legal elements, the practical elements, and the risk considerations for you as the employer. So taking those in order, we begin first thinking about the legal elements here. There are two really major points within the immigration rules and associated guidance to be aware of. The first and most important point is that where an individual has an outstanding application with the Home Office, or where they've submitted an application, that application is pending, the application will be automatically withdrawn if that individual leaves the common travel area. And the common travel area, just for reference, is the UK, Ireland, the Isle of Man, and the Channel Islands. So if an individual has submitted their application and they are then leaving that common travel area, that application is viewed as being automatically withdrawn. Separately, if an individual has what is called Section 3C leave, and they actually exit the UK, so we're not talking about the common travel area anymore, just the UK, they have 3C leave and they exit the UK, their 3C leave will automatically lapse. Now, 3C leave, just by way of reminder, is the type of status that an individual has where they have submitted an in-time application from within the UK. So it's obviously going to be relevant to these types of scenario. If an individual has a visa that allows them to live and work here, and they're applying for a new one, and they make the application before the previous visa expired, when the visa expires, if the application remains pending, if it's still with the Home Office, their status in the UK is protected, and it basically automatically extends until a decision is made, and that is called 3C leave. So to recap there, because I realize that's a lot of technical points, from a legal perspective, if an individual makes their application from within the UK and they then seek to leave the common travel area before the application is decided, the application is automatically withdrawn. And if that individual was benefiting from 3C leave because their previous visa had expired in the interim, their 3C leave will lapse. So that's the legal position. And as you might expect, the ramifications here are potentially quite serious, because what I'm really saying is if an individual is trying to leave the UK when they've already got an application with the Home Office, it's going to cause them no end of problems if they do so. So turning then to the practical elements there for you and the individual to be considering. First of all, it's just worth noting as an aside that from a practical and procedural perspective, this issue is becoming increasingly prevalent. For those who've been doing immigration work for a long time, you may recall that, years ago, it used to be the case that you'd have to send off a passport as part of a visa application. And if the passport was sent to the Home Office, well, then the individual couldn't travel anyway, and this wasn't really an issue. And as the Home Office has moved away from that, and certainly now as it moves to what really is a mostly digital system, individuals keep their passport. That means they have the ability to travel, which obviously then increases the likelihood of this being an issue. But also, it means that you need to be a little bit proactive with this, because a migrant worker might assume, and they couldn't necessarily be blamed for assuming this, that if they've still got their passport and they've submitted a visa application, well, they're still allowed to travel because they still have their passport. So it's just about being aware of the issue and being aware of situations where it might cause a problem. So that's the starting point in terms of practical considerations. The next kind of minor point to just be aware of is that there are some potential financial considerations here. If an individual has submitted their visa application and it has then been withdrawn by virtue of them leaving the common travel area, they will get a refund of their immigration health surcharge because the application hasn't been granted. But they may not get a refund of any visa application fees that were associated with submitting the application in the first place. So potentially there is some financial loss here if this situation arises. Now that obviously is relevant, but what is more relevant, and the main point that I want to make here really, is that the issues are obviously around ongoing status. That's the key practical consideration here. If you have an individual who submitted a visa application in the UK, obviously they've done so because they're intending to stay here and continue working for you. And if that application is then withdrawn, well, then their status isn't going to continue because they no longer have an application with the Home Office that can grant them a visa. That's kind of, I suppose, the initial element. The second element, and obviously the logical conclusion there is, well, okay, what does that mean for them moving forward? They've left the UK, application's been withdrawn. They're now in a position where potentially they don't have any status in the UK, depending on whether or not they were relying on 3C leave. But even if they do have some sort of status, it's going to expire soon and they need some type of new visa application. Now, this is where it becomes complicated, and every case is different, and there will be, practicalities to an individual's particular situation. And really, if you're in this position, you need to be seeking advice. But in the vast majority of cases, the remedy here would be submitting a new application from outside of the UK, essentially starting the application process again. And that in of itself comes with additional issues around finances in terms of actually, getting a new application submitted, getting a new cause assigned, and also just the practicalities of, well, they're stuck overseas in the interim. So you never want to be in that position, really. And that brings us quite neatly to the final point, which is around risk. The point here to make is just that, you should be advising people not to do this realistically. There will be situations where urgent travel is required, and I suppose in those situations you just deal with the fallout. And equally, it's probably worth noting that the Home Office don't always automatically withdraw the application. They don't necessarily have the mechanism to do so. We have had cases where individuals have travelled when they shouldn't have, and the visa's still been granted. But that isn't how it's supposed to work. You should place no reliance on that. And so realistically, as I say, you should just be telling people not to do this. And one final point does occur to me, sorry, that it's just worth noting as well. This issue often rears its head because the individual wants to submit a visa application before they have to. So you may have a scenario where an individual's visa expires in late January, for example, and that worker might be a bit twitchy. They want to get their new application in. They want to feel a bit more secure in their status. Fair enough. But they also want to travel for 3 weeks over Christmas. Those two things don't necessarily work well together. And in that scenario, what you should be saying is, well, look, travel over Christmas as you're planning. And then when you get back in January, we've got, for example, 3 weeks before your visa expires. You submit the application within those 3 weeks. There is no issue. Um, so just be aware of that. Please be alive to the fact that this does crop up, and it can crop up without you really being forewarned. And so if you've got any migrant workers whose visas are due to expire around the holiday period, just have a think about what their intentions are, and maybe work with them to ensure that there are no issues arising. And so moving on to the skilled worker visa, and a bit of an update in relation to a few points. I'm going to begin with supplementary employment. For those who are not aware, or potentially just by way of reminder, when we talk about supplementary employment, what we are referring to here is an individual who is sponsored to do work in the UK, so skilled worker, and they obviously are conducting work in accordance with their sponsorship, but they want to do some additional work. Ordinarily, it would be for another employer. That is permitted, but in limited circumstances. Now, it had been the case until the raft of changes that we saw in April of this year. It had been the case that supplementary employment was very restrictive. It was possible, but only if it was at the same professional level and within the same SOC code as the main sponsored employer to deal with that. It is now the case that that has been relaxed. It was a bit of a shock. We didn't really know that they were going to relax these rules so much. But basically, supplementary employment is now permitted in any circumstance where an individual is conducting a role that would be eligible for sponsorship from a skill level perspective. So if the role falls into a SOC code that appears within tables 1 to 3 of appendix skilled occupations, so those are the eligible SOC codes for visa sponsorship. If it falls within one of those SOC codes, supplementary employment is possible. There are still some restrictions. So it's still the case that supplementary employment can only be for up to 20 hours a week. It's still the case that it can't interfere with the main work, the main sponsored work. So it has to take place outside of the main hours of work there. But the point is, it no longer has to be at the same professional level and within the same SOC code. So the work can be in a completely different area as long as that area is eligible for sponsorship in of itself. And just to absolutely clarify this point, because I realize it can be slightly misleading. When I'm talking about the skill level needing to be satisfied, there is no salary requirement to that. Supplementary employment doesn't come with any particular salary thresholds. It's just in terms of assessing whether or not eligibility criteria are satisfied. Where does that SOC code sit in terms of actually being eligible for sponsorship? One key point on this is that the messaging around the entire kind of liberalization of these rules has been a bit unclear. Because of the wording of the changes in rules, it initially seemed that this relaxation would only apply to individuals who had their COS assigned after 4th of April of this year. The Home Office did confirm verbally that actually wasn't the case, and that it just applied to anyone. And they have subsequently amended the guidance to remove any distinction so that it is clear that it's just applicable across the board. Okay. And the final point to note, just before I hand you back to Alex, is we've referenced the right to work guidance today. It has been updated, and it does provide clear details of how you go about checking right to work in a supplementary employment scenario. So do view that guidance to check exactly what you need to be doing. Alex.
Brilliant. Thanks, Mark. So talking about salaries, just wanted to touch on some of the changes that have happened since the 4th of April around the salary thresholds to qualify for sponsorship. This is a familiar slide you will have seen on previous webinars, just reminding us of the thresholds that apply, the general threshold and the going rate. And obviously there was a huge increase in April, 4th of April this year to 38,700 in the general threshold. Still discounts available for PhDs, roles on the immigration salary list and new entrants, but a big increase in that. But probably of greater significance was the increase in the going rates based on new ONS data, increased to the 50th percentile of earnings that really ratcheted up the rates, particularly for certain sectors where there'd been a big increase over recent years in the salaries that were payable. What I wanted to touch on this morning is what can probably only be described as the shambles in the going rates. Going rate saga, I'm going to call it, that has happened since the 4th of April, and just really to flag that you may need to revisit the roles that you sponsor for and look at eligibility based on the going rates. Just to give you it in a timeline format so you can see how well the Home Office has administered this. 4th of April, we had the statement of changes, big increase in salary requirements being implemented. Then on the 10th of July this year, some sponsor guidance was issued without any notice or announcement that suddenly said there were a whole load of lower going rates for various occupation codes, essentially granting lower going rates as a concession because apparently there had been some data and drafting errors. And then there was an SMS notification on the 28th of August confirming that some going rates were stated to be higher than intended, so underlying the data and drafting error. Then 10th of September, the lower going rates, so the sort of the new correct ones, as it were, in the sponsor guidance, they're put into the immigration rules and details provided of occupation codes. But also, it was identified there's going to be a whole raft of salary increases due to earlier errors. So we've got, since the 4th of April, some decreasing and now some increasing. And then from the 8th of October this year, we've got those salary reductions, as stated in the sponsor guidance, now put into the relevant appendix that you look at, which has got all the SOC codes to assess salary, and also details of the salary increases for going rates for some roles that are going to be applying whether COS was assigned on or after the 8th of October. I'll put a question mark, partly for humour purposes, what's going to happen next, but it's not been a particularly slick effort in terms of these changes, and quite a bit for employers to navigate. Just to give you some examples of what's happened here. So we've got reduced going rates for a whole raft of SOC codes, and I've pulled out just some examples here. Biological scientists, I know lots of people with us today sponsor people in those roles. The standard going rate, that's gone from 41,900 to 38,000, and the transitional going rate, i.e. that applies to those who were sponsored before the 4th of April this year, has gone down from 32,100 to 28,100. Web design professionals, standard going rate stays the same, but the transitional going rate, that's gone down quite significantly for what are difficult roles to fill, from 35,800 to 29,000. So huge reduction in the transitional going rates. But some have increased, which is less helpful. Health service, public health managers and directors. So the standard going rate up from 43,900 to 50,500. Ouch. Also an increase in the transitional going rate. And then advertising accounts managers and creative directors, standard going rate up from 40,000 to 43,700. And the transitional going rate increased from 32,600 to 35,000, the transitional one applying to those where the COS was assigned before the 4th of April this year. So what have we had? We've had a period of a few months where we've essentially got one set of salaries that applied for the 24th of April to the 10th of July, as per the rules that came into force on the 4th of July. For the period 10 July to 7 October, we've got the salaries that applied as set out in the sponsor guidance, reduced. And then from the 8th of October onwards, we've got new salaries applying again, some of which are increased quite significantly. So a bit of a messy exercise. What's the message here? Don't panic. Everything should be fine in terms of applications that have been made. There isn't a problem sort of retrospectively, if you like. What I think you do want to be doing is reviewing the SOC codes that you typically sponsor people for to assess the impact of this. Obviously, there may be some roles which you thought were not eligible for sponsorship, under the new 4th April rules, where it turns out the salary is much lower for the going rate than you first thought. Several £1,000s in some cases. Conversely, of course, there might be some roles where you thought, oh, we're in business, we can sponsor here, and the rate's gone up significantly, and those roles will no longer be eligible for sponsorship based on your salary spine. So have a look at that, work out what the impact is. And I think final point, keep an eye out for transitional arrangements for extensions. So will there be any? So for people that have sort of been sponsored under the lower salary arrangements and now there are higher salaries from the 8th of October, what will happen when they extend? We don't know. I'm not convinced there necessarily will be any arrangements for those people, but that's something we're going to have to keep an eye out. And you should probably proactively have on your radar if you've got people that are coming up for their expiry and need to apply to extend, to assess what the impact of that is. Other than that, there's not been a huge amount going on the skilled worker territory, but that is probably sufficient to be getting to grips with at the moment. Patricia, you wanted to give us a bit of a roundup.
Yes, just quickly, thanks, Alex, and good morning, everyone. Some practical points, things that we've noticed as well. For example, the first one is delays to visa processing in the UK due to lack of appointment. I think I just quickly saw someone making a comment about that. This is basically due to the Home Office changing service provider. And also the issue is exacerbated by an increase of number of applications made in the run-up of Christmas and the deadline to phase out all the BRPs by the 31st of December 2024. So if someone is applying from within the UK, it's very important that they do everything they can to use the UK Immigration ID Check app that will prevent them from having to book an appointment and attend in person. So that will resolve the issue. I appreciate it's not always possible. There are some issues with the UK VI account. So sometimes if you need to update it and it's not updated in time, you are unable to use it. So you have to attend an in-person appointment. So this is very important. The Home Office has advised that they are regularly making additional appointment available. So keep monitoring that. And one thing I would say I appreciate from a business point of view, it's not always useful if you are recruiting someone new, but for the migrants, the important thing is that they get their application in before their visa expires. And if they are struggling to get an appointment, well, then that can be addressed for at least you're giving a grace period. So if you have any issues after a while, please do get in touch and we'll see what we can do to assist you. Quickly, another one, as I mentioned, 31st of December 2024, the Home Office is replacing all BRPs with eVisas. So that means everyone needs to create a UK VI account, and they will all be issued with an e-visa. So that is an important change. And also the Home Office has said if you carry out a right to work check, those who have indefinite leave to remain or indefinite leave to enter in the UK in their passport in any other form, hard copy, a physical document, they should apply for a no time limit, and then they will get an e-visa for that. So you'll be able to check their status online. And another quick change, as you may have heard, the Home Office will eventually replace the sponsor management system SMS with the sponsor UK system. This is currently being tested by those under the government authorized exchange visa route. We have very little details about how the whole system will work, but we have been promised by the Home Office that it will simplify things for us all. So fingers crossed. We hope that will be the case. And ETA, as you know, everyone coming to the UK will soon need to apply for an ETA to come to the UK, just like when you travel to the States or Canada. And there are some deadlines. So for non-European, they can start applying for the ETA as of the 27th of November. and they will need an ETA by the time they travel on the 8th of January next year. And for European is they can start on the 5th of March next year, and they will need one from the 2nd of April 2025. So this is a quick roundup. Just want to finish off about the UKVI account. It's very important that you ensure that everyone that you sponsor, any migrant workers that worked for you, that they have registered their UKVI account and link and look at their status online, because and they keep it up to date, because that's the way forward from the 1st of January next year. Any question, just get in touch. Thanks, Alex.
Brilliant. Thanks, Patricia. So just finally, before 5 minutes for questions, what about the new Labour government and what might we have on the horizon? I think it's interesting times. They've said, haven't they, that their number one mission is growth. But as probably they are finding in taxation and other areas, there are tensions, including in the immigration sphere, to how that aim sits with public policy demands that have so many different facets to them. I think the short answer is at the moment there is nothing significant by way of change on the horizon. I think there were 40 odd bills in the King's speech. Only 2 touched on immigration. One was asylum related, and one is around the establishment of a statutory agency called Skills England. I'll come back to that in a moment. Okay, most immigration stuff is done through secondary legislation, but it's not really a focus. There's nothing of note in the budget on immigration, which actually is quite unusual. What has happened, the Home Secretary made an announcement to Parliament on the 30th of July, essentially saying, well, we're going to continue to implement the Conservatives' 5-point plan to reduce net migration. So no loosening of the salary requirements that were increased on the 4th of April, as we've seen. Continuing to have restrictions, it seems, on dependence of international students. That's been very significant, seemingly in a reduction in international student numbers to the financial detriment to the higher education sector, and restricting the ability of care workers to bring dependents as well. So no changes on the face of it around those quite significant restrictions that came in earlier this year. The Migration Advisory Committee that advises the government, that is to be strengthened, so getting more staff, forecasting future trends, trying to identify sectors that supposedly have an over-reliance on international staff. And I think the government sees a real desire to want to sort of link in with skills. So where are there skill shortages in the economy? What should they be doing around that? And the MAC playing a key role as part of that. Bridget Phillipson is committed on the Today programme, no less, to retain the graduate route. It's probably a relief to higher education colleagues amongst us, given how key that is to the attractiveness of the UK as a destination for international students. But as I say, no loosening at the moment of the rules on student visas. And there is an expectation that the policies will reduce net migration, the government says, to a couple of 100,000. That's what they're saying. We'll come to what the OBR says in a moment. But they are looking to have new measures that address what they see as the root causes of the UK's over-reliance on international recruitment. So that sense of where are the skills shortages, what can we do about it? We want to move away, the government seems to be saying, from relying on international labour, which probably isn't comforting to many businesses and sectors in the short to medium term. There's a notable increase in enforcement action at the moment. So there's been more sponsor licence suspensions and revocations last year than any time since Brexit. So that is firmly up on the radar, and more illegal working raids as well around illegal working and the penalties that, of course, increased in January this year quite significantly to up to £60,000 per worker. The minimum income requirements for a partner visa, that is set currently at 29,000. They're not going to increase that at the moment. It's subject to a MAC review, so not at this stage going to go up to 34,500 and then 38,700 as originally considered. I'll leave you this thought before we have some time for questions. The Office for Budget Responsibility, so the OBR, so they have said in some of their analysis that net migration will settle at around 350,000 per year over the next 5 years. And that is based just on the changes that have been implemented by the Conservatives that are obviously now filtering through to the numbers that are there in terms of net migration. But have a listen to this. So the net fiscal impact of 350,000 annual net migration. So if you like, the benefit of having 350,000 people by way of net migration is a reduction in public sector borrowing of 7.4 billion. 7.4 billion. So that's more than twice the increase given to the armed forces in the last budget at a time of obviously what's considered to be huge political instability. So that summarizes the tension, doesn't it? The bottom line is that immigration is a key lever for growth. It's a key lever for tax revenue. 6.2 billion increased tax revenues come from those 350,000, according to the ABR. If you had more, you'd have more tax revenue on the face of it. That tension is going to play out across, I think, lots of areas of government policy over the next few months, and immigration is one of them. And it may be that as the government comes under pressure, needs to deliver, public finances under strain, that they will look to make some changes, at least for some sectors, and that may be of some comfort to employers. It's 10:41. We've got 3 or 4 minutes for questions. Mark, have you picked out any themes that you'd like to cover off?
Yeah, absolutely. Yeah. So had a lot of questions in. There have been 2 key themes that I just want to make sure we address before we finish. So the first is we've had a lot of comments and questions in relation to kind of the move away from biometric residence permits and to use of eVisas. Obviously, we don't have time to go through all of that today, but I just want to flag a couple of points. A lot of the questions around will the Home Office be updating the right to work check, the process, the online process, so that when you're conducting those checks, you can actually see what type of status an individual has. I don't believe they've made any comments in relation to this. And so at the moment, as I'm sure you're all aware, you check the status, and whilst it will confirm that they have a right to work, it won't tell you what their visa type is. There will be clues. If they're a student, the normal student restriction conditions will be listed there, but it won't say student visa. So at the moment, there don't seem to be any plans. Having said that, I would be surprised if, as they move to an all digital system, they don't make some tweaks and make it very clear what type of visa status we have or we're dealing with. So really just to watch this space on that one. The other point on in a similar vein, it has been the case that most BRP holders will have a national insurance number issued to them when the biometric permit is issued, because of the way that the Home Office and DWP kind of talk to each other when doing that. That is not the case with eVisas. And again, at the moment, it doesn't appear that there are any plans to implement that. And currently, the situation is if an individual is being granted an eVisa, they will have to separately apply for their national insurance number. That's the case at the moment. Again, whether or not that changes, we just don't know. I think the point here is there are going to be a lot of teething issues with this changeover, and so you may have to be a bit nimble in terms of your approach, and we're all going to have to be a bit nimble while the Home Office system kind of catches up. The other one thing I did want to say on a different theme, we've had a lot of questions just off the back of the point I was making in relation to leaving the UK with a pending application, and several comments about making use of the option on the certificate of sponsorship to tick the little box that says the migrant needs to leave and re-enter the UK during the period of approval. Now, just to dispel any kind of misunderstanding there, the period of approval is not the period where the Home Office are making a decision on the application. The period of approval that is being referred to there is the actual visa period. So ticking that box does not negate anything that I was saying earlier in relation to them leaving the UK. It's not the case that you can tick that box and then they can leave and it won't be withdrawn. That isn't how that works. So please don't rely on that.
Great, thanks. Any points you wanted to pick up, Patricia? Probably got about 30 seconds or so. No? Okay, that's fine. I think you're on mute anyway. A couple of questions I'll pick out quickly. Somebody asked about unpaid interns. Should a right to work check be done on them? I mean, I think that's probably a fairly low risk category, all things considered, but clearly the most robust thing, particularly if you're a sponsor, is to do right to work checks. So if that's manageable, I think it's sensible. Somebody asked about being based abroad. A right to work check's required. If somebody is based abroad, no, they're not. If somebody is employed by you but working entirely abroad, they're not essentially subject to UK immigration control. But beware of the fact they may come into the UK from time to time when based abroad, which would take things potentially into a different territory in terms of visa requirements. And someone asked about agency staff. Key point there is make sure the agencies are doing the check. If it's manageable, the numbers aren't too high, I think it's sensible to ask the agency to perhaps provide copies of the checks that they've done, so you've got some comfort that the staff that you've got have the right to work, but at the very least, make sure it's incumbent on them to be doing those checks, and that's clear in the agreements that you have with them. It is 10:45. Thanks so much for being with us. It's been great to have you. We'll make the recording available. Slides will be available. Otherwise, have a great day and see you or speak to you soon. Many thanks.